morning, everybody. Today we have senior advocate Jeevakumar with us to discuss about the new criminal laws enacted. Sir, what is the plus and minus of the new enacted laws?
Welcome, Faisal. Today, this is our hottest topic in a debate which is discussed throughout the country. Even the international humanity, the community is also concerned with what other things are taking shape in India in the legal field. According to me, Faisal, the plus is a change, is a welcoming feature. Change is a welcoming feature, whereas the minus is a constitution failure took place. In brief, I will say the minus is the content. The content is a minus of the new legislation.
Some people are saying that speedy justice is rendered as well as time-bound proceedings were enacted in this new law. What is your view, sir?
You will say there are two proverbs, phraseologies, maxims exist in our legal field. One is the delayed justice is a denial of justice. The another famous or the popular maxim is a hurried justice is a burial of justice. Therefore, if you say that it is some delay caused in that rendering justice, at the same time you would also consider and think about some hurried justice is also giving negative effect in this field.
So what is your view in zero FIR that is incorporated in this new law?
Factually speaking, zero FIR is not the brainchild of new law. Even in Tamil Nadu, it is introduced in the 2016. The online FIR registration, the zero FIR, is introduced even in the previous law. As per the previous law alone, as per the previous law, they permits the state governments or the government to enact the facility of online FIR, online registration.
Why you are opposing these new laws and its content, sir?
You say that, as I already told you, that some welcoming features in the new law, whereas the law it denies all the rights of the lawyers, judges, as well as the public people. If you say, if you take the case of lawyers, lawyers would be fixed some penal punishment for giving, even discussing with the claims. They may give some some discussion regarding with the claimant to frame a case, how to conduct a case. Some new ideas were mooted, and that discussions they were taken as a penal offence under section 113 of BNSS, the Bharatiya Nyaya Sanhita, that gives that punishment even for life, which goes to life punishment, as well as some fine would also be imposed against the liar. That I will say against the advocates. The second thing is, it is snatching the powers of judges, and the powers were given to the quasi-judiciary authorities, namely even Firga level tahsildars. The remand power, the remand of a prisoner was only in the hands of the full-time advocates during our previous system. But at the same time, now the new law gives the remand power. The power of remand was given to the quasi-judiciary like tahsildars and others. So therefore, in one angle, it is also against the act of and the law, rule of law. This is against the judges. There are a lot of it. I will tell it in briefly. As well as the other aspect, it is totally against the public. Particularly, you are taking the section of BNS 343 and 226. They are permitting even the handcuffing an innocent person. During the previous days, even as per the Lalit Kumar case for the FIR, in Sunil Mitra case, handcuffing matter, one could not be denied the human rights by way of handcuffing without the permission of the court. There are established settled law, even as per our apex top court, they are giving rulings against the handcuffing of an innocence. Therefore, as per the previous law, you can't have anybody else without any valid and legal reason. But here, you can, one police can create reason. One police could create reason. Therefore, it enhances the powers of police and as well as the military. Even as per the new law, martial law, the powers are given a lot of powers to the military. Therefore, it enhances the powers of police and the military, and it reduces the powers of the judges. It minimizes the role of lawyers, and it denies the democratic right. Even in the encounter deaths, as per the new provisions, the encounter deaths would be justified by the police. Therefore, since giving power to the jungle Raj, the police and the military, which are the creatures of the fascist, I will say the society would be a crimeless society. Our dream, what is your imagination? It would be a crimeless society. But here, they want to create another crimeful society, which there are going to be a lot of ruins and the theft, chain snatching, killings, murders. They are going to create such a Raj, which is the brain thought of Mr. Amit Shah.
In old law, as per Lalita Kumari judgment, the police has to register a FIR within 24 hours without preliminary inquiry. But in contrast, the new criminal law allows 14 days to register a FIR. What is your view, sir?
This question is a very fine question. That's why we are opposing the legislation of new law. Even the previous days, as you rightly told, the Lalita Kumari case, the FIR would be registered even after the occurrence within 24 hours, because there would be no exaggeration, there would be no imagination. If the FIR is lodged belatedly, then there would be colorful thought, belated, and vexatious allegations would be found in the belated FIR. If you lodge a complaint even after the occurrence, then it would be fresh and without any imagination and exaggeration. So therefore, if you give a long rope for 14 days, the police would misuse it, and that there are a lot of many allegations, new allegations would be incorporated, and false fixations of charges would be taken place. Therefore, this is a sufficient cause for us that you say while you are saying that speedy justice, but why you are giving time for 14 days for lodging the complaint, for lodging the FIR? Therefore, your statement is true, it is false, because you are delaying the justice, the system. The system is more delayed by you by the changes. Therefore, according to us, this is, I want to underline the point, this is it will establish us, it will expose us the true picture of that changes and the new legislation of new law.
The legislation of new laws were made in Parliament. Why do you find a fault in these laws?
Oh, you are telling that it is made in the Parliament. Okay, to some extent it is true. It was given assent by President of India in December 25. But at the time of discussing the new law, the legislation of new law, 143 MPs, the lawmakers, the member of Parliament, were suspended in the parliamentary proceedings. Therefore, it is not a full-throated discussion took place. While you are telling that the law is age-old 163 years, and it is a colonial period, the law of colonial period law. What is the hurry you are making such a new legislation? You would give sufficient time. Therefore, you may convene a new parliamentary session or a special session for discussing the age-old colonial Indian Penal Code as well as the Indian Evidence Act and the Criminal Procedure Code. Now you name it as the Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, and Bharatiya Shakshya Abhinigam. You are naming it a new name. According to me, you may change the name. It is a honey-coated poison. According to me, it is a honey-coated poison. I want the discussion in democratic aspects. Even the Bharatiya ruling party, Bharatiya Janata MP, namely one Sangeet Kumari, and as well as Jas Kaur Meena, the women MPs of parliamentary, they showed their opposition in resolving this new legislation without giving sufficient time to discuss about the women rights. The women rights in new law. They themselves, the BJP MPs themselves, they are giving dissent to that hurried discussion. Therefore, according to me, these the legislation of new laws are not resolved in democratic way. another discussion is needed, another special session is needed. If you want to throw out the slavery items of British era, if you want to bring independent India, independent and giving powers, more powers to the citizens of India, more democracy to India, you make another discussion, you make another parliament, the new parliament, and therefore according to me, the discussion, it is authoritarian. The legislation of new laws are not in democratic way, it is authoritarian, unilateral, biased, and the one Mr. Vajpayee, who is the convener by the BJP party, who is the convener of reforms in new criminal laws, himself says 70% of the law is an old law. Therefore, it is old law, old wine in new bottle or old wine in old bottle. Many opposition parties say only 90% of the law is old. While the BJP themselves saying that 70% of the law is old. Therefore, the law is old. Some changes, some amendments were made by you. Therefore, another discussion. All people are wants to incorporate, so include and exclude new items in law. Therefore, another discussion is needed. Another debate is needed. That will be taken place throughout the country.
Thank you for your time, sir. We will discuss more in detail in the upcoming sessions.
Welcoming, Mr. Professor, for giving this opportunity, and we will meet another next series for this.